Hi everyone. In this video I'll be talking about legal theory. I'll be introducing you to what the law means. In other words, what do we mean when we say this is the law? How do we find the law? Where do we find it? Legal theory can help us answer some of these questions. So in brief, legal theory is the philosophy that underlies the law. When judges deliver their reasons, for example, there are a range of assumptions that underpin those reasons. If you know legal theory, you'll have a really good tool set to understand some of the hidden assumptions in judicial reasoning. I think that legal theory is probably the most important subject that you could possibly learn at law school. Unfortunately, most law schools don't teach it right at the front of your degree, at the very beginning, I mean. They actually teach it towards the end. This is very confusing because without knowing legal theory, it's going to be very difficult to quickly understand why judges disagree with each other, what is the underlying political or moral value, for example, that they disagree with. Because if judges write 200 pages in really technical language, you may struggle to understand why they're disagreeing with each other or what they're saying if you focus too much on the technical aspect. Whereas if you knew legal theory, you'd be able to focus more on the moral or political aspect and grasp what they're trying to say much quicker. Secondly, and related to the first point, it actually helps you to quickly find the ratio or the essence of a judgment. So instead of reading through all 200 pages, you might be able to skim read it and find the really key points much faster. And thirdly, it will help you approach legal problems, especially hypothetical problems, much more logically and systematically. There are basically three schools of legal thought that most universities talk about. These are just broad categories, and to some extent they are an oversimplification. So do keep in mind that there is some intermingling between categories. And even, for example, legal positivists, they struggle to define or agree with each other as to what positivism actually is. But in summary, you could say, for example, that legal positivism is a theory that the law comes from social facts. So social facts are things such as legislation, case law, parliaments, Congress, conventions, those kinds of things that are easily factual in nature, and they arise in the community. And then the officials, usually the government, they take notice of those facts and they promulgate rules which are considered to be law. Now, these rules don't have to be morally based or morally correct. For example, in Nazi Germany, they had a lot of laws, but they just weren't morally correct laws. But they were still laws according to legal positivism. Natural law, on the other hand, would probably argue that the law in Nazi Germany wasn't actually law because it couldn't be logically deduced from the nature of mankind. So natural lawyers say that the law can be deduced independently of social facts, so it doesn't matter what the legislation or case law says. All that matters is what's right and wrong based on the nature of man. So as an example, if you look at mankind, they're always trying to achieve goals, and a natural lawyer might argue that the fact that they achieve goals and they try to work towards a meaningful direction suggests to us that murder should be illegal because that would violate the natural state of mankind. Whereas in Nazi Germany, obviously murder was perfectly legal in many cases. The third one is customary law. Customary law is essentially the product of voluntary social practice in a community, or in other words, what that means is it's something which a community practices usually over a period of time, and that practice itself is considered to be the law. So as an example, in the High Court case of Mabo, the High Court found that certain Aboriginal or Indigenous communities in Australia had customary law to do with the relationship to the land. They had certain practices, and these practices were capable of constituting a voluntary social practice, and therefore became sort of like a custom in that community, or a tradition. So Murray Rothbard actually summarizes what I said in the previous slide. As you can see, he says, in fact, the legal principles of any society can be established in three alternative ways: either by following the traditional custom of a tribe or a community, or by obeying the ad hoc or arbitrary will of those who rule the government apparatus, or C, by the use of man's reason in discovering the natural law. So let's move on to legal positivism. If we break it down, there are broadly three main planks to legal positivism. And these planks help us to identify what the law in a particular community could be. So as in the first plank is the pedigree thesis, the second one is the separability thesis, and the third is the discretion thesis. So the pedigree thesis basically argues that the legal validity of a particular thing or action is a function of certain social facts. Usually these social facts are the ones that are recognized by officials in that society. And so that's the pedigree thesis. Something can't be considered to be law unless it's rooted in social facts, and that those social facts are given recognition by the officials of a society. The second one is called the separability thesis. This basically argues that what the law is and what the morality of a particular thing or action is are totally different things. It's not necessary that the law should be morally correct. There is no link between the law and morality. In other words, they're conceptually distinct. The third discretion thesis basically argues that judges decide difficult cases by making new law. So positivism thinks of a legal community as having a certain number or system of laws, and at some point the law will just basically run out. And in a hard case where the law has effectively run out or finished, the judge will have to decide by making a new law and exercise a discretion. Now, I did point out earlier that there's disagreement in the sense that these are all broad categories and there's a lot of complexity in them. So there is disagreement among positivists, and the theory is basically elusive. And that's an exact quote from Joseph Raz, who is one of the most influential positivists. There are also two different schools of positivism. One is called exclusive and the other is called inclusive. So exclusive is much, much stronger in terms of believing in the separability thesis, because they totally reject the idea that any moral criteria can be a standard for legal validity. On the other hand, inclusive positivists, which may include actually Herbert Hart, they believe that in some situations there is a possibility of having a moral criteria for validity. So they're not as strong about the separability thesis, or they don't believe in it to the same extent. So as an example, the US Constitution has a Bill of Rights, and that sets out certain human rights. And so an inclusive positivist, and this is actually one of the examples that Hart gives, might suggest that the law itself requires consideration of some moral factor of validity, because the language in the law is often very general and broad, and it effectively incorporates certain moral criteria, whereas an exclusive positivist will be very reluctant to accept that kind of argument. Now, obviously, different countries have different laws, and the one thing that all positivists agree on is the pedigree thesis, where they do all believe that ultimately rules are found in social sources like legislation and case law. So whether those sources talk about moral factors of validity or not, it's always brought down to the source of law, or the pedigree of law, being things like legislation and cases by judges. Now, every society has different judges, every society has different parliaments. So that means that every society or country will have different laws. So obviously the US Constitution and the Australian Constitution are very different. So in Australia, we have two main levels of government. We actually have three levels of government, but the third level is local government, which comes underneath the state government. So we have the federal government, and I call it a federal government on purpose. It's not a central government. A central government is much different from a federal government. A central government is effectively what you'd find in a unitary state, like the United Kingdom or maybe New Zealand. But a federal government is one that aims to be representative of all the local states. So in Australia we have a parliament, and that parliament has representatives elected by state electorates. So for example, in the Senate, it's considered to be a state's house, where the representatives are elected on the basis of a state electorate. And similarly, there's actually a constitutional guarantee in the lower house, or the House of Representatives, where each state has a certain allocated number of representatives that they must have or cannot go lower than in the lower house. Now, I've talked about the federal and state government, and that's what the Constitution recognizes. However, the Constitution doesn't really talk about individuals. So individuals fall as a subcategory under federal and state, but they're not explicitly recognized, in the sense that it doesn't say that, for example, that individuals can have certain powers, or that individuals can leave Australia, because some people have actually tried to argue in the cases such as the one I've noted there, Fife and Victoria, that individuals can actually leave Australia. So the Constitution is basically a methodologically collectivist constitution, rather than one that focuses on individuals. Now, of course, it does mention a few individuals, like the Queen and the Governor General, but when it talks about individuals, it usually just uses the broad term, the people. It just says the people, or the people of the states. It doesn't say, anything that would suggest that individuals may have a right to secede. Although you can always argue that. There are ways to interpret the law in different ways, and some people might suggest that there are ways for individuals to secede. And when I say secession, by the way, I mean leaving the country and forming your own country. So in effect, Australia is a positivist society at a broad level. Now, there's going to be different judges who have different views. Some judges might be natural lawyers, but they operate within a framework of positivism, where they might be inclusive positivists, where they look at the law and they say, okay, the law is telling me to look at some sort of moral standard to decide this case. But they can't go outside the law. So for example, they can't say, okay, I'm going to look at the Constitution today, or I'm going to look at this legislation, and I'm just going to totally ignore it, and I'm just going to do whatever I want. They look to the words of the law, and that's their first priority. And that's why I say that it's somewhat of a positivist society. So there are three main sources in Australia of the actual law. The one is the Federal or Commonwealth Constitution, which sets up the Commonwealth Parliament. Then there are the constitutions of each of the 6 states. Each of these states and the federal parliament have their own legislation. It's a system of federalism where the parliaments of federal and state are not having unlimited power. They have to operate within the context of checks and balances. And then the third aspect is the precedent from judicial decisions. So if the High Court of Australia says something in one of its cases, that actually influences the law going forward. And the same thing with the Supreme Courts in each state. When they say something, that influences the law of that state. There are 2 cases that I think are really worth looking at. I'll go through these cases in future videos as well, but I think one of the main ones is Ferry and Burvett, which was decided by the High Court of Australia. Now, I find this case to be very interesting. It was decided in World War I. I won't go through the whole case here. I'll leave that for a future video. But basically, if you read that case in full, it will give you a very good understanding of Australia's political and federal system. And the second one is, of course, the engineers case, which is probably the single most influential case in Australian history. So I've talked about positivism. Let's quickly go over natural law. So some natural lawyers argue that there are universally applicable social laws that can be scientifically ascertained. So just like some economists say that there's something called the law of supply and demand, some natural lawyers say that certain things are against human nature, logically, or through deduction. So if you ask a natural lawyer, like, what is law, what does that mean? A natural law would answer that legal principles can be derived a priori, meaning that they pre-exist any man-made legislation. So law is not an artificial construct, but it's something which simply just uses reason. It relies on the use of reason, in effect. So obviously different people can come to different conclusions about what's right and what's wrong. So one natural lawyer might say that murder is wrong. Another natural lawyer might use the logic and the nature of man, the same kind of reasoning, to say that murder is actually right. But then ultimately there's going to be a flaw in one of their reasoning, because with logic you have premises, and then those premises lead to certain conclusions. And if your premises are correct, the conclusion should follow. But if you have a conclusion that murder is wrong or murder is right, it should be backed up logically by those premises. So if there's a dispute between two natural lawyers, the way to resolve that would be to go through and check the premises and see which premise is wrong and which premise is right. And whoever is wrong or right, that's when you'll be able to find out who's ultimately wrong or right. It's a little bit more complex than that, but in effect, there's a thing called philosophical logic, and there's a whole field of logic in philosophy which could be used by natural lawyers, and actually is used by natural lawyers, or at least some of them, to deduce what the law should be, or what the law is, rather. And none of this relies on looking at legislation or case law. So does the natural law necessarily conflict with positivism? A lot of people think that you can only be a natural lawyer or you can only be a positivist. That's simply not true. As I mentioned earlier, there are certain people who consider themselves to be inclusive positivists. And those people think that if you have a piece of legislation or constitution which actually says to you that go and look at this moral moral standard. Like, for example, the U.S. Bill of Rights has a lot of has 10 amendments in the Bill of Rights, and some of those relate to things which are somewhat general and broad and could be considered to be moral in nature. If you have a law like that, then you could effectively bring in the natural law. You might argue that the legislation incorporates natural law to some extent. So that's how you can be both a natural lawyer and a positivist. So many people have argued that moral criteria cannot be part of the law, and as I mentioned, those people are called exclusive positivists, and that's what's most commonly associated with positivism. But it's important to note that the inclusive positivism argument proves or sort of suggests that you can also be a natural lawyer while also being a positivist. And I would recommend looking at Coke, Chief Justice Coke, C-O-K-E. Look at some of his cases from hundreds of years ago, when he actually used standards that were not necessarily, strictly speaking, technically in the law. Now, there is a compromise position, or what I would call a compromise position, between the pure natural law approach of someone like Murray Rothbard and the exclusive positivist approach of someone like Joseph Raz. So that would be legal interpretivism, which was pioneered by Ronald Dworkin. So unlike a natural lawyer who would argue that there are pre-existing universal rights that can be deduced logically, Dworkin does not agree with that view. But Dworkin also does not agree with the positivist view. So he disagrees with both positivism and natural law. So his position is basically that the law involves values and principles, and so positivists are wrong to say that you can just look at legislation and sort of find the rule. There's no such thing as a rule. It's much more complicated than that. It actually involves interpretation, which is why his theory is called interpretivism. So in the process of interpretation, people actually put their own values and principles into that process. Because you can always find a precedent on one side that says one thing, and then another precedent on the other side that says something completely the opposite, and you've got to weigh those two different things and come to a decision as to what the law actually is in that particular case. And so that's what he says is one of the main flaws with the positivist theory, which is actually somewhat of a simplistic theory that suggests you can just simply look at the social facts and the law and the legislation and the cases and just sort of find the law. It's really not that simple, because two people can look at the same exact thing or the same exact case or legislation and come to completely different conclusions. And the reason they do that is because they're weighing the principles and values differently. Finally, I just wanted to point out that when we talk about the law, we don't need to be talking about government. Government and law are totally different things. And so you could have positivism does talk about officials, but those officials don't have to be government officials. It could be just people in society or in the community who recognize as being leaders of that community. So while positivism does generally talk about government, there are other ways of looking at it that don't involve government. So, for example, David Friedman in The Machinery of Freedom has talked about the country of Iceland, where for 300 years there was no government, or at least no coercive government that used force to exact taxes and do other things that a government like we have today. So in Iceland, it was a mostly voluntary society. If someone committed a crime, there was no police force funded by taxes that would go and put that person in jail. What used to happen was they would have social ostracism, or rather, or to put it differently, social pressure would be applied on that person, and that person would have to pay a fine often rather than going to jail. So there'd be competing sets of laws in the same country. So it was more like what we'd call a polycentric society, rather than a centralized society where there's only one government or a couple of governments and everyone has to follow those laws. It was more like a competing society where people would have their own laws for different communities. So that example of Iceland proves that you don't need a coercive government when you're talking about law. You can still have law and have a completely privatized society. Finally, I just wanted to give a few tips on how to think like a lawyer. And these are some of the things you'll pick up as you go through your undergraduate degree. First of all, don't read more than you have to. I made that mistake when I first started out. I would get a case and I would try to read every single word. You really don't have the time to be doing that, and even if you did, you may only want to read every single word on certain very important cases like the ones I mentioned earlier, like for example the engineer's case. But a lot of other cases you can sort of read key sections and bring out the key principles. Secondly, understand the facts of each case. Really focus on the facts as your primary thing. Do read the relevant facts. Don't skim read that part, because often exam questions will literally use the same facts but just change the names. Thirdly, a lot of people think that because some law universities allow you to bring the textbook in, that it's going to be easy. You really shouldn't have to look at your textbook more than a couple of times in, like, say, a 2-hour exam. You should be having summary notes that you can use to quickly skim through whatever you need, and then you have the rest of the knowledge in your head. You can't afford to waste time flipping through a textbook. 4. Attend court hearings in your local city. They're free and open to the public if you live in a Western society. Of course, if you're living somewhere like communist China or something and watching this video, I'm not sure, but definitely in Australia, you can go to any court practically, except for certain courts which are to do with where the hearings are suppressed for various reasons, such as national security or something like that. But basically, most of the time, the court hearings are free, and you can just rock up and just get a practical understanding of what's in your textbook. That will really help you in the exams as well. And 5th, try to get some experience as a paralegal or legal secretary assisting a lawyer while you're studying. You might just work, for example, 1 day a week or something like that, and just basically get some practical experience that will help you once again apply the theoretical knowledge in practice and do much better on exams. When you're writing answers for law exams, it's really important to acknowledge that there are different possible answers. And that's what I talked about earlier when I said that a different positivist can look at the same exact piece of legislation and come to completely different conclusions. So I can look at, for example, the Australian Constitution, Section 92, which talks about freedom of movement between people of the states, and I can come to a completely different conclusion than 99% of the High Court judges by looking at the same exact words. And that's really because we're not dealing with mathematics here. This is not 1 + 1 = 2. It's an art form, not a science. And so if you can bring that out in your answers by, for example, you can say, we can look at this law this way, or we can look at it this way and lead to this conclusion. That makes your answers much more sophisticated, and you'll get higher marks. And related to the same point is that there is never a single correct answer in law. You can't say that this is what the law is. It's very rare you can say that, actually, because law is inherently political. So even if you think that it means something, it might be that a judge might decide the exact opposite thing. So I'll go back to Section 92 of the Constitution, the Australian Constitution. So I think that Section 92 clearly means that you cannot interfere with the right of Australian citizens to move throughout the states however they please. But the High Court has said that you can. And I think that when you have a section that's so unambiguous on its face, it literally says that there is going to be freedom of intercourse, trade and commerce, and yet the judges still say something totally different. That proves that there's never an objectively correct answer in the law, because you can always have a judge who, for whatever reason, maybe political or different values, will flip the law on its head and say something totally different. And the main values that judges hold in the modern day it's called statism. So statism means a belief in the notion of a coercive government that has a right to rule over individuals. The opposite of statism is voluntarism, which refers to a belief in consensual interactions or individual liberty. So those are the two values that are competing always in the law, and when you have different lawyers interpreting things in different ways, it's usually because they're either prioritizing individual liberty or they're prioritizing the government. In conclusion, study legal theory. Even if it's something which you dabble into in your spare time, just read a bit of legal theory. It really helps you in your other subjects. And read it early. Don't wait till the university forces you to read it. There are a variety of schools of legal thought, as we went through the main ones: positivism, natural law, and customary law. I didn't go into customary law in a lot of detail because it's almost never a major focus of university level courses. So mainly positivism and natural law are the ones you should look into. I do think that it's important to note that the law doesn't require the existence of a government. You can still have law in a fully privatized society without a government, such as Iceland. The recommended reading at the end of this presentation will give you more detail on some of the things I've said, and I highly recommend obviously reading those. So the first one would be the Ronald Dworkin book, where he talks about legal interpretism, and he also describes positivism and natural law in that same book. It's really worth picking up. The other one is Murray Rothbard, The Ethics of Liberty, where he talks about the natural law, and he basically sets out a full natural law argument for what the law should be. The third one is John Hasnas, The Myth of the Rule of Law. It's an article with the Wisconsin Law Review. It effectively talks about how the law is very indeterminate. There is actually no such thing as a single objective correct answer for any part of the law. It's always inherently political and always dependent on the values of the person who's interpreting the law. Finally, if you'd like to go into more detail on the case study of Iceland and other examples like that, I'd recommend the book by Edward Stringham, Anarchy and the Law. Thanks for listening, and if you enjoyed this presentation, please subscribe. Thank you.